Welcome to Housing for Good, a podcast dedicated to housing topics and issues affecting our communities in McPherson County and beyond. With years of experience and expertise, hosts Chris Goodson and Karolyn Moore discuss housing challenges and opportunities with other experts from a variety of housing fields.
Good afternoon and welcome to another podcast of Housing for Good. I'm Karolyn.
And I'm Chris.
Okay, Chris, I think that we need to remind everybody that's listening that we have our Brush Up Mac coming up, and the deadline to get your application in as a homeowner is March 15.
Yes.
And the deadline for volunteers would be March 30.
Okay. So if you have a team that maybe you want to come help us this year, that would be incredible.
Yeah.
And remember, it's countywide. However, we really need teams in those communities to participate.
Yeah.
So that would be great if we could get some other teams from some other communities so we can spread this thing out. It really helps our seniors stay in their homes.
It does. And I just want to encourage you, if you're thinking you've got a church youth group, or maybe you've got a small group or people that you work with and you want to put together a team but you've never done it, just know that part of the reason the deadline for the homeowners is 2 weeks before the volunteers is because once I have my volunteer teams, the leader of that team comes out, looks at the homes, what they want to have done, and decides which one of them their team could tackle, because they'll have different levels of expertise, different levels of jobs they can do.
And we get a free T-shirt. That's the fun part. And what I would really love to see, quite honestly, is to get some more of the kids involved.
Yeah.
I think that we have a 5th grade class.
Yes.
I think they're in Washington School District.
They are. Yep.
And so I would love to see more kids get involved. That's really fun for us and fun for the homeowners.
Yeah.
To see those young kids working on their yards, mowing and pulling weeds and picking up leaves and stuff.
Yeah.
So, yeah. That would be amazing. So that's all the news for today. But we have our guests back today. So tell me about what
we have Christopher Moe and Michael Hilleary with Kansas Legal Services. This is part 2 of our podcast on tenant landlord laws. And we're just really wanting to inform everybody. As a tenant, you have rights. As a landlord, you have rights. And how do we maneuver this to make it so that everybody knows what they are obligated to do and what they...
And I think we're going to focus this time on the paper trail maybe a little bit.
Yeah.
And then also we're going to talk a little bit about what the landlord's rights are. Because
exactly.
they have rights as well. So, so you guys, you want to take this a little bit.
Yeah, sure. For sure. Well, sort of what we were talking about last time and we were sort of getting to is I think there's definitely some best practices that as a tenant and as a landlord, like we provide assistance to tenants almost exclusively. But there's best practices for both sides. One of those I think is most important. Don't talk to each other unless you write it down. That's it. Like, I will, people will say like, my tenants, they're doing this, that, and the other, or someone saying like my landlord hasn't fixed the ceiling, the roof, the leaky pipes, whatever it is. Text them. Have that text message conversation that you create in your phone is an indelible record. It is a writing. The courts will see that as a writing. You could contract to marry over a text message. You could contract to buy a building over text message. That's how powerful it simply being written down is. It's the new cocktail napkin at the club from the 50s, if you remember this.
Awesome, yeah.
Yeah.
What about, so if I call somebody, if I call my landlord or my tenant and they don't answer and I leave a voicemail, is that? Don't leave a voicemail. Okay.
Just text them.
Okay. Texting everybody. That's what you're supposed to do.
Okay.
Text.
Yeah. Or email. Email is great because, text messages, depending on the different phones, this is something like, if we imagine these relationships, making your car payments or something like that, we want a record of that. Our bank statements, there's a reason why we get this is what happened, this is when it happened, this is how it happened. Our phones don't necessarily keep all that information. You have phones that just say oh yeah, this was on October 13th. Doesn't say what time. Doesn't say who it's from. Emails are really nice because I sent this email to them at this time. They know for a fact it happened then. that's why we always want communicate in writing.
So we left off on our last conversation, our last podcast, with if you are a tenant and the landlord is not fixing something.
Exactly.
And so walk us through that step, because we already talked about the lease agreement and what goes on there. But walk us through the steps. If there's a problem, what do I do?
Mm-hmm. So there's a couple different options that a tenant can exercise. We already hit in our last meeting here about how the tenant does not have the weapon in the arsenal of withholding rent if the landlord isn't fixing
Exactly.
stuff. These are two wholly separate obligations. One of the landlord to fix stuff is wholly exclusive from the tenant's obligation to pay rent. So now that I got that out of the way, there are certain things that the tenant can do to help create and bolster that paper trail to show, hey, I have put the landlord on very firm notice of these issues here, okay? So those can be your general maintenance requests. You want to make sure that you're keeping copies not only for yourself, but you're giving one to the landlord as well. There are these things called payment under protest forms, which specifically reference, hi, I have a duty to pay rent. You have a duty to fix things. I'm putting you on notice that you are out of compliance with the lease agreement and the statute by not fixing the water heater, or by not replacing the weather stripping on the door, or insert deficiency here. And then these are all things that can be in your arsenal for that potential and eventual small claims court case, should you end up needing to file action against your landlord after you end up leaving the premises. Because more often than not, and we've seen it before, where there can be litigation between a landlord and a tenant, and after the litigation, the landlord and the tenant continue to be landlord and tenant. That doesn't necessarily spell the end of that relationship. Crazier things have happened.
Yeah.
But more often than not, people are a little uncomfortable, right, to say the least, navigating that relationship with their landlord. Really, they're afraid that they might be stirring the pot by saying, hey, I've asked about this 3 times and it's still not being fixed. Like we talked about before, the options for, affordable, safe housing is not where it necessarily needs to be. And so folks are willing to, dance with the devil that they know as opposed to the one that they don't. And so what that ends up happening is, hey, you still can have redress, if once you end up leaving, you have up to 5 years as the statute of limitations for contractual damages, okay? And that's like what a lease damages under a lease are, because a lease is a contract, so you would have 5 years from the date of the breach, or once you're notified of the damages that occurred underneath that document, right? So if you had a security deposit snafu and you didn't find out that the landlord was trying to wrongfully withhold that amount until after you had left, well, it would be 5 years from the date that you were put on notice that, you were being wronged and that they were holding on to an amount that they shouldn't have.
I had no idea it was that long.
Let's clarify that real quick. If you didn't get your security deposit back in 2020, you can still get it back from your landlord.
Yes.
Okay.
No idea that they had that people had that much time.
No, I didn't either. Because if you're struggling, sometimes you can't think clearly enough to maybe do some of these things. However, if I find another place to live and I'm stabilized, I may have some time to call legal services and then go, this is what happened to me. Can you help me through this process so I can go back and get that? I mean, that just makes sense to me. But sometimes when you're going through something, it's really hard to think clearly enough to be able to do that.
Well, and I think this is why we call it like best practices. Like the best weapon in that fight is if you kept a good record. Like even if you're going through a rough situation, all you need to do is be keeping track of those records.
Interesting. Okay.
So if you're being evicted, right, you get the 3-day notice because it's a non-payment of rent issue. There's a statute in here in the Residential Landlord and Tenant Act that says if you are being evicted on the basis of non-payment of rent, you have to assert all of your possible defenses that could help mitigate that dollar amount. So we call that in the business a compulsory counterclaim, right? So that would be, hey, landlord, you're saying that I owe you $500, but you never fixed that water heater. And so I have been damaged as well. And so I'm actually countersuing you for, $100. And so there's a statute here that says if the basis of the eviction action is non-payment of rent, you have to assert all of these condition issue-based defenses to help mitigate that dollar amount. So that's where, more often than not, that's really where you end up finding, landlords being put on the spot and being asked about, maybe not fixing certain things, or about tenants living in situations that they shouldn't be living in. It's usually under that scope of, okay, well, now you're being evicted and there's some sort of money due on the back end. And then that's normally when the tenant has the opportunity to go about and they have their awesome paper trail and they can show the judge, well, this is my offset for this amount.
So they're going to have to show when they told the landlord, like a specific date and time, I told you on this day. You can't just say, well, I told you to fix that sink, but with nothing in writing and not when they told anybody. Well, you'd have to have all of that paper trail to be able to show to the judge that, yes, this happened. Is that what you're saying?
Well, we think that's best practice by any means. Now, certainly you could go and just testify. You could give your own testimony, but as I'm sure Michael will back me up on this as well, in any kind of legal situation, right? Not just housing, but, even in like domestic or in criminal law, any kind of legal situation, when you are looking and analyzing at a set of facts, right? And you are working with your client and you guys see it this way, right? This situation played out this way and this should have happened. Well, anytime you and your client want to go ahead and try to tell that same set of facts to a third party who they may see it a different way, you're introducing a level of risk there, right? Mm-hmm. And so...
What about, so let's pretend like I'm getting evicted. Mm-hmm. He didn't fix anything.
Sure.
And I forgot to make a paper trail. Can I go back into the house before I'm thrown out, I guess, and take photos of the things in the house? Is that documentation for the things in the home? Because that would be a last-minute ditch thing that somebody... I'm trying to think like somebody who potentially is being evicted and facing something in there, dealing with a lot of stress. It's like, well, I could walk back into this house and then put this light fixture doesn't work. This does... is that a thing?
Yeah, sure. And there's two interesting things about that. At the outset of your tenancy, the landlord and the tenant are bound to do an inspection of the house within 5 days of the start of the rental period. This binds both the landlord and the tenant. Both the landlord and the tenant are supposed to do this. If they both don't do it, well, okay, we're missing some evidence. But you as the tenant can go through and be like, hey, I took a picture of this hole in the wall, this, whatever it is, this crack in the window, there's clear signs of leaking on the side of the stove, or hey, what are those things under the
drip pans? The
drip pans under the burners. I love a landlord will say like, well, I had to buy new drip pans, $75 a pop. Mm-hmm. So you owe me, So you owe me $300.
Man, those are some good drip pans.
They are $40 light bulbs. I don't even know where these landlords are getting them.
Wow.
And they'll but you're supposed to give the tenant and the landlord are bound at the outset of the lease to create this list of the problems that are happening in the house, or just the condition of the house. Yes, you absolutely can take pictures. I encourage everyone to take pictures. People love to take videos. Mm-hmm. Please stop. Just take pictures. Pictures are so much easier to print and share send, and they don't have the blurry interlude, which is like, I swear, just look at this problem. Look at this smoke alarm doesn't work. I got the cigarette right here. The smoke alarm doesn't work. Great. I don't need to see that. Just tell me,
take a photo.
If it is something that you can take a picture of, take a picture of it.
I'm envisioning somebody standing at a smoke detector with their cigarette, trying to get it not go off or whatever.
Sprinkler system
That's
doesn't
awesome.
work.
Oh, this is fun.
But you can absolutely take pictures. And the thing that when we talk about best practices is making the best evidence so you can most easily show your claim. A picture from the first day the leak started is great because it's a picture. The metadata contains the timestamp on the picture. And I can be like, look here, I got a picture from May where this leak had started. There's never going to be perfect evidence of anything. Mm-hmm. But you have some good evidence, and that's enough to take the landlord to court and really raise questions. Because at the end of the day, sort of what we want to do in a lot of these situations is resolve this thing civilly. Okay, we have some problems. Landlords, they have issues as well. If you're a tenant who's like, destroying something, you got a dog who's ripping up the hardwood floors or whatever it is, that's fine. You want to protect your investment.
Absolutely.
And I think one of the things that we see a lot is that landlords, will, for good or bad reasons, simply like neglect the thing. You neglect an issue in the place you own. Like maybe there's a foundation issue. Okay, maybe I'm a landlord and I'm like, can I push that out 2 years before it becomes a real problem? And then the day it becomes a real problem is the day your tenant's calling you and saying, I want to get out of here. There's a bunch of water and mice in the basement, because the foundation finally cracked after the freeze or whatever it is. There's reasons on both sides of these issues. And the fact of the matter is that if you are using your building that you own to house other humans, you have responsibilities to maintain that place in habitable condition. Life happens. Houses are terrible. We can all agree on that. They just fall apart all the time. Roofs, I don't even know how they stay on. It's bad, but you have to fix it. It's your investment. It's your building. Those tenants are just paying to live there. So we all have responsibilities, and we all want to protect our investment. We want to protect our investment as landlords, and we want to protect our investment as tenants, where we're just like, okay, we agreed $800 to live here. That's it. I'm not paying to fix your roof or your windows or put new light bulbs in your house. I wouldn't ask Advance Auto Parts to pay me to put new headlights on my car, So I'm not going to ask a tenant to buy me a bunch of new light bulbs. It's just not how a contractual relationship exists. I don't have to pay for new lights in a rental car, do I?
I never thought about light bulbs before. Have you?
No.
Light bulbs are a big one where it's. Yeah, and the same thing, landlords will also ask for payment for things like, I had to have the carpet steam cleaned. Absolutely not. You can steam clean your own carpet on your own dime. I lived there. The carpet's going to get dirty. I've got kids. They're going to run around. I'm not responsible for the normal wear and tear on any building that I live in. They'll ask, we got to repaint these walls because you smoke. I'm just like, you never said I couldn't smoke. There's nothing in the lease that says I can't smoke. You never said I can't smoke. My grandma lives in the back room. She does nothing but smoke, and so no, so you can't charge me to repaint. You can't charge me to paint if you know there's kids living here. Kids are going to write on the walls. I'm going to stop them. I'm going to try to clean up. I'm going to keep it as clean as I certainly can possible. But sometimes kids get loose with a Sharpie. It's a reality of the world. It's your building. You rented it to a family. That's your mistake. That's your prerogative. You can do that or you cannot. If you want to rent to a bunch of college kids and hope they do better, good luck.
Yeah. I've actually seen somebody lose money on one of those because of most of those issues that you just talked about.
Exactly. Yeah.
Not knowing that was normal wear and tear, and they absolutely could not do that.
And normal wear and tear is a really cool issue in landlord-tenant law, I think, because it's a point in the law where there's no one ever has set down A, B, C, and D are normal wear and tear.
Yeah.
So you can always make that argument that hey, this thing that happened, that's normal wear and tear. I love the drip pans in the stove. I used the stove for cooking. That's how the drip pans got dirty. It's not full of roaches. I've kept it clean. It's fine. Drip pans just get blackened by being near, especially if you have a gas stove. Mm-hmm. I used it. I used this thing for its purpose.
Yeah.
You can't charge me to fix the thing I used for the purpose in the room for its purpose, in the building for its purpose. What are you doing? Yeah, I think there's a great argument to be made there. And there's, on the other side, also a good argument. You can look at those drip pans. Did you just pour ramen into your open oven? Okay, no. You didn't clean it. That's not normal wear and tear. Normal people don't use the stove this way. Normal people don't put plastic containers in the stove. I've seen this happen. It melts.
Oh yeah.
Put they have the casserole in the Tupperware, and they're just I know how to heat this. I'm going to put it in. I'm just going to pop it in the oven. And that thing just melts all over the place.
Oh, my goodness.
And that's the thing is tenants, you're responsible for the damages caused by yourself, your foolishness, and the foolishness of your guests and children.
Okay.
So there's a balance there.
So there's definitely, you got to consider, I can't even talk. This is Crazy.
I've never heard of anybody putting their Tupperware in the oven, but
So either have I.
You see, I've got these pictures that the clients send me.
Oh my goodness. Oh wow.
So we see a lot of stuff. We see things where like the tenants have done things wrong. I've seen bullet holes in doorways. I've seen we've got mice in oven, possum on oven, roach coming out of
light switch.
oh my gosh.
And that sort of thing is just like melted, like
an apartment.
yeah. Well, this the other thing is like I can't believe the landlord hasn't fixed my sliding glass door that I broke because I threw something
really
through
clean,
it. It was I could
just walk right through it.
Oh, wow.
And it's just like there's a balancing act of things that are the tenant's responsibility and things that are the landlord's responsibility. And I think that where this is all going is that in fairness, I think that if people are able to have a civil conversation about like, I did that, responsible, two adults talking to each other, that's what the court is supposed to be. Mm-hmm. And having all the facts out on the table. Like, no, I'm not paying for you to get new light bulbs, Sam, but I will pay for the fact that my kid hit a baseball in the living room and it went through the window. Mm-hmm. I'll pay for that. That's on me. But the light bulbs, the fact that the plumbing doesn't work all the time, that's on you.
Mm-hmm. Yeah.
It's your house. It's your building.
we keep referring to these landlord-tenant laws, and I know that there's a lot of information out there. Can you tell us where I could get my own copy?
Oh, absolutely. So if you were to actually just Google the Kansas Residential Landlord and Tenant Act, you can find it on the Revisor of Statutes, but there's actually the first link I believe that you click on comes from the Housing and Credit Counseling Bureau from Shawnee County. And it's got a complete printout of, I believe it's 13 pages of the entirety of the Kansas Residential Landlord Tenant Act. It's not written in Latin or in Old English or anything like that. I'm not going to say that it's a real page turner either. It's not, the great American novel here, but it does spell out, again, what these duties of the landlord are, what the duties of the tenant are, what the process is to go about navigating your lease and rental relationship with your landlord. It's all right there, and it's very accessible. Again, if you can Control F, find your way through, search through. Oh, what's this say about security deposits? Oh, well, there's a statute that talks about that.
All about it.
So that is very helpful for our listeners. If you have a question about Landlord-Tenant Act, you can always Google that and find that information.
Yeah, it's very easy to find the Kansas landlord-tenant laws, and it is also very easy to just call Kansas Legal Services.
Yes, it is. What's that number again?
Okay, that number is 1-800-723-6953.
So, we've been talking, did I interrupt you?
I just had one thing to say is if people just called me to ask legal questions before there was a horrendous problem, I would be so happy. I would have no work, and I would be so happy.
Would you be happy?
Yeah.
I don't know. You might be happy for a while, but it would get a little boring, don't you think? I think it would be. So,
pursue my hobbies.
We've been mostly talking about tenant side of things, but I'd like to kind of focus a little more on what it is for a landlord, because there are some pretty bad tenants out there sometimes, and landlords are really having to navigate that a little bit, and I've heard some horror stories on that as well, where you just can't get somebody to move out, and they're tearing up the place and maybe doing illegal activities and all kinds of stuff. So what would you say to them?
Yeah. Well, step number one would be identifying what type of tenancy are we trying to terminate. Are we working with a month-to-month lease? Are we working on a year lease? Because if we're working with a month-to-month lease agreement, to terminate that, you need a 30-day notice tied to a rent-paying day. Okay, if we're dealing with a non-payment of rent type issue, and that's why you're trying to terminate, the 3-day notice is applicable for either type of tenancy, and that's the one that you would use. Now, if we're dealing with, the 1-year lease agreement and you're dealing with anything other than non-payment of rent, usually the 30-day notice procedure is going to be the choose your own adventure route, towards, either resolving that issue with the lease defect, you're playing music too loud, smoking in your unit, that kind of thing. Or the tenancy will terminate at the conclusion of the 30 days if nothing is remedied within the 14. So step number one is figuring out what kind of contractual relationship do you have with your tenant. And then what is the basis that you're trying to terminate it for? Is it the non-payment of rent, or is there some sort of a lease violation issue, or are you just trying to not renew the existing lease agreement?
Yeah, I think one of the things that happens a lot is that if you set out a lease and you met this person, you posted your rental property online, and you found this person, they are renting from you, then you're pretty secure. You have that lease. You could say like, hey, they're supposed to do this, that, and the other. They're throwing crazy parties. They're damaging my property, whatever it is. And you could pretty easily evict them. It's not hard. I think the ones that it gets more difficult are, situations where, I agreed for this guy. Maybe it was just all oral, like, it was just like, Ricky, you can come live in, the house on my property, whatever it is. And something bad is happening. That's fine. The Kansas Landlord Tenant Act that we were talking about, that covers all those scenarios. If you just have an oral lease, right, that I just like, you can come stay on my property out on the back 40. Cool. That's fine. That creates at law a month-to-month tenancy. The law says that. It just tells us what it does. The only other situation would be is that if you actually put a date on it, or if you agreed like week to week, it'd be the only other time it would be different. But if you have a month-to-month tenancy, it's a pretty good situation for a landlord to have a month-to-month tenancy, because first day, any day of the month, you can, not any day of the month, any first day of the month, you can be like, all right, you're out. That's it. It's over. No stopping it. There's no like, but I paid the rent. Doesn't matter. Rental agreement is terminated at the end of these 30 days. It's not great, but you will get that person out of there. They can come to court and talk until they're blue in the face about whatever the problem is, but that's fine. Your rental period is over. Same thing with the end of the year. Have some mechanism in place whereby you could say like, okay, we agree that if one of us doesn't say you're staying for another year by the 6 months or 3 months, whatever you guys contract for, it should be 6 months, but you're out. End of the year, year's over, you're out. That's it. Then no court in the land is going to deny you your eviction. I mean, if they are a holdover tenant in that situation.
So I've been seeing a lot of clients that we work with when we move somebody into housing, one of the requirements is they have to be given a year lease.
Sure.
But then when that's time for the next year lease, they go month to month.
Okay.
So we see that routinely, that it switches over then.
Yeah.
I've always wondered what the reasoning was behind that.
I don't think there's a reason behind it. As a person who's been in that situation before, it gives the illusion of like more freedom of the contracting parties after the first year. Like I guaranteed my investment for 1 year, and then, it's sort of like wishy-washy. If you last a year, you're a good tenant, you can stay, and then there's sort of no guardrails on it. I can leave, the tenant can leave too. If you have a month-to-month tenancy, boogie, you can just like, power went out, I'm leaving. I can leave in 30 days. Just same thing. Month's over. If you didn't tell them by the 15th that you're staying, you're out. So it does. I think it gives more freedom to the two parties.
Okay.
Why we do that preferably, I don't know.
Yeah.
If it is based on the fact that like, now I can kick them out whenever I want. Good on them.
And I've always said that, the month-to-month tenancy, it's a good thing and a bad thing, right?
Yeah.
Like it serves a purpose where if you're not necessarily sure you want to be tied to a spot for a whole year, maybe you're in between jobs, or, you found this place and then you're in the process of moving, or you're going to be expanding your family or something like that. Certainly if it's a temporary type situation, the month-to-month tenancy I think is great. And there's also a statute, in the KRALTA that says, absent some sort of a renewal term in the lease that says, this shall auto-renew for another 1 year term. There's a statute that says all of these leases will auto-renew on a month-to-month basis in the absence of an express.
Okay.
So that is another reason probably why, just because that's a default term in statute. That, after the 1 year lease agreement, if there's not renewal language, then it just will auto-renew on the month-to-month basis.
Okay.
Probably to give both parties that flexibility. But I just want to make sure that we're getting in front of this too, that if you have any intention on staying at a unit for longer than just a general number I'm throwing out there, like 6 months or so, really look at trying to get a longer term lease, a 1 year lease agreement, because you don't want to be in a situation where, something happens or you have like a weird interaction with a landlord or a maintenance person, or you're in a situation where there's some issues afoot, and you feel as though you can't go and have a candid conversation with your landlord about the condition issues or maintenance problems that you're having because, I'm scared I'm going to get this 30-day notice, and they're just not going to renew me because it cuts both ways.
Yeah.
So I just have seen that happen, before, where tenants will feel as though they're at a significant disadvantage in those communications with the landlord because I'm on a month-to-month lease and I don't have anywhere to go and I don't want to rock the boat. But certainly if you're on good footing with your landlord and you foresee yourself staying here, longer than just the foreseeable future, then I would certainly try to engage in those conversations with property management, the landlord, about trying to get that 1-year lease if it makes sense for you and your family.
So I'm curious if there's anything else. What else? Have we missed anything talking about all these different issues? Is there anything that you feel like we need to highlight before we say goodbye today?
I do. Okay, so the one thing, and I feel like we could talk with you guys all day. But something that I really want to make sure that we talk about is what happens when an eviction case is actually filed, right? Because a lot of folks are really concerned with what's my eviction record look like, right?
Exactly.
So there's not like a standardized database, right, that all landlords and property management people run tenants through, and that say rent to this person, don't rent to this person because of these records, right? So each landlord, each property management company, they can kind of have their own criteria for going about that.
Unless you live in a small town, and then there is a secret list.
There probably is.
Yes.
Yeah.
Well, and the best thing to do about your eviction record is, I think, have a good relationship with your landlord so as they don't file that case because there's no expungement for an eviction on your record.
You just read my mind. I was going to ask that.
Even if they file an eviction and we figure it out, my mom's gonna help me pay this month, I'm gonna pay and I'm gonna stay and let bygones. We'll dismiss the case, right? That doesn't remove it from your record. It will still always be there. So the best thing to do is have a good relationship with your landlord. They're a person, you're a person. There might be an imbalance of power, but call Cancel Legal Services. Let's see if there's really a problem that can't be resolved. If you do have an eviction on your record and you've resolved all your problems, you don't owe any money to that old landlord anymore, you can do things like, again, call us, but you can talk about getting a satisfaction of judgment where you file something in the case that says this was settled. And that's really one of the better things we can do, because then if a landlord looks at your application, and who knows if they do this, they should look deeper into the cases, but they might not. But you can provide them with satisfaction judgment. Okay, I was evicted back in Douglas County or Harper County or wherever, but I figured that all out. Here's my satisfaction judgment that shows me and that landlord are square.
So that would be very similar to if I run my credit report and an old bill comes up that maybe I've paid it off, but it's still showing up there. I can go on and put a dispute that this was paid off.
This was paid. Yes,
Okay.
exactly.
Okay.
And
It's actually easier than doing that.
And does it show up on your credit report if you get an eviction? Does that show up on a credit report?
Maybe.
If you have a judgment,
It's a judgment.
Then it would.
part of
Yeah.
that.
Then it would. Okay.
Okay.
So how are they finding out about this then if you have an eviction and there's no? Where's it come
They
from?
just take home records.
Yeah, it's public records, right?
Okay, okay.
And this is something I like to use as an example is I could file a case against Michael and try to evict him. I'm not his landlord.
He's your boss, right?
Right. Yes.
The B word again.
And so obviously, I'm not his landlord. I'm not.
Yeah.
That would be totally baseless. But kind of like what we talked about, the court will happily take my money, the filing fee, and all that stuff, and will show up to the first hearing, and the judge will say, "Well, there's no jurisdiction here for this case.
Yeah.
This is dismissed." But that record of me filing that case against Michael will still show
Even though
up.
it was completely frivolous.
Exactly.
Oh, my
Dismissed on its
word.
first day, the first blush of a judge. And I do have one other thing I would love to do, if you guys would entertain this.
Go for it.
All right.
Okay, what we're going to do is Chris is going to play the judge,
Oh boy.
all right?
Okay.
And you guys are about to walk into eviction court. You've gotten your 3-day notice. You've been served with papers. Ready?
Yeah.
Go.
Do you admit or deny that you owe the $500 outlined in the petition?
I don't owe that guy anything.
Nice.
Do you admit or deny that you owe what's outlined in the petition?
I deny it. I don't know what he's talking about.
Very good.
I know you guys can't see because it's a podcast, but they just hit 1,000 here.
That is true. And this is to illustrate this. I love to do this when I do presentations, stuff like that. And Chris did a great job of actually enumerating the claim. Usually the judge will just be like, do you owe this person money? Do you live there? Do you owe them money? And most people say, well, yes, I live there. You know, maybe I do owe them money. I don't know. They're saying they filed this case that says I owe money. Yes, I guess. Mm-hmm. That's it. Yes.
Judgment.
You're done. You're evicted. That's it.
Or
That's
like we talked about before, where folks are in this is their first interaction with the court system, and they're being asked by the judge in the black robe.
The scary guy at the top over there.
Exactly.
Yep.
And
Yes.
a lot of times, too, tenants might owe $300 of $500, but is $3,500? No, you can deny. You can say, no, I don't owe the $500 because I actually owe $300, right? And so tenants, they'll get into this yes but no kind of game, and the judge or the court in some cases will just hear the yes part and enter in a default judgment.
Wow.
So
Okay, that brings up another question I have. If you are being evicted and you want to fight it, or you want to go to court and explain your side to the judge, do you have the right to have an attorney?
No,
Why is that?
because it's civil law. The Sixth Amendment gives the accused shall have the right to counsel, is what it says generally. I'm paraphrasing the Sixth Amendment. But it allows you to have legal counsel when the government has come to take away your liberty, right?
Okay.
To put you in jail, to fine you. The government fines, the state of Kansas fines you. That is the only time that you're ever granted an attorney in any court in this country.
Okay.
All these other matters, a divorce, an eviction, an employment law case, Social Security, you do not get an attorney. You have to seek an attorney. You have to buy an attorney.
Oh, I see what you're saying. I was confused for a minute. Now
Yeah.
I know what you're saying.
Yeah. Only when the government comes to take away your stuff, the government then will give you an attorney.
Okay, but I do have the right to hire an attorney.
Absolutely.
To go with me to eviction court,
Yes.
to represent me because I'm overwhelmed. I don't understand what's happening. I am intimidated.
Just any reason.
Maybe I'm afraid of this landlord over here, so
You can hire an attorney for anything. You can
Okay.
hire an attorney to talk to the phone company for you.
Okay.
You know? But yeah, so you can always bring an attorney to any situation. I don't recommend it. Attorneys are weird. But so people are just like, aren't I supposed to get an attorney? Yeah, I'm in court. Aren't I supposed to get an attorney? No. In the land of civil law, which is most of the law, you have to get an attorney. And the place you can get an attorney is Kansas Legal Services.
Oh, what's that phone number?
absolutely. Oh, yeah, that phone number is 1-800-723-6953.
And in many cases, like we also talk about this, you might not need an attorney to be there to, be pointing at the judge and yelling at the landlord and standing in your place representing you. In many cases, I've found with lots of people is you need an attorney to help you understand which issues matter. So many times, tenants will come and be like, they lied to me. They said they were going to remove leaves from my property, and they never did. That was in the thing. They said they were going to remove the leaves and cut the lawn, and they never did. And you're just like, I don't care about that at all. And this is the thing, is you want to cut it down to like what's actually going to matter to the judge, what's actually going to matter to the court, what's going to get this case solved. Half of the time, it's like, did they actually give you a notice that they were going to evict you? Well, no. Why? Well, then their case lacks jurisdiction, and I'm going to get dismissed the first day. That's easy. Did the notice say that it was going to terminate your lease? No. Well, I'll just get it dismissed the first day. Like, I don't need to hear. The judge doesn't need to hear that, like, oh, he's the most terrible landlord, and he called my Aunt Stacy. Whatever. You air, people so frequently air all these grievances when it's just like,
Right.
Does the stove work? No. Does any electricity work? No. Okay, we've got a case here. We've got a different case here.
Yeah.
I don't care what they said, how mean they are. The fact of the matter is, like, there are very limited issues in these cases. It's about the house. Does the house work? Yes? No? Let's figure it out. Do you want to stay there? Yes? No? Let's figure it out. This place is falling apart around you. This landlord isn't invested in making any repairs to this property. They just want to cut it down, build a sixplex on top of it. Okay, cool. Let's get you out of there and make sure you still got your security deposit.
Yeah.
Yeah. That was
Okay.
this has been very informative.
Oh, I've learned so much.
me too.
I always learn so much when we have people come in and talk with us. So I want to thank everybody for listening today. If you'd be interested in talking with us, being on our podcast, or you know somebody that would be a good topic, good person to talk with about a different subject, then let us know. Drop us a line. Leave a review. Let us know how we're doing. What are we doing right? What are we doing wrong? Housing for Good at McPhersonHC.org. Thank you so much for listening.
Yeah, and have a great day.
Thank you, guys.
Thank you.